for today's case. Am I missing anybody else who's co-counseling or anybody else like that who's part of your team, gentlemen? No? Okay. Thank you so much, Mr. Goggin. I understand that you represent the appellant in this matter. Would you like to reserve time for rebuttal?
Yes, Your Honor, 5 minutes.
Okay, I have made that notation. And as you're probably familiar, I'm your timekeeper, one of the powers and authority of center chair, if we were in a courtroom. So you may proceed, counsel.
Thank you, Your Honor. May it please the court. This is an appeal of an order from the lower tribunal, which denied, in this case, Royal Woods' motion to compel appraisal. So this is one of a series of cases recently which has sought to kind of clarify and otherwise address how and when appraisal may be compelled. And in this particular case, I would say that there is a factual distinction or a factual analysis necessary, as the broad scheme that has been recently enacted by this court in line with Supreme Court decisions Johnson and Lycia, through this court's decision in Leeward, in Villaggio, and in Palmetto, has generally suggested that two broad, items are required in order to compel appraisal. The first is, of course, a determination of coverage, which through those cases is an admission of coverage, as well as more recently established in Leeward, a ripeness of that matter, which involves a reasonable opportunity to investigate the claim or the loss on the part of the presumably non-moving party, in this case, the insurer.
Mr. Goggin, can I interrupt? Because as I see the issues have been framed for us, you're taking the position that this issue deals with specifically appraiser versus your opponent says this issue deals with coverage. And we all know the case law that if there's a dispute as to coverage, it's well within the court's means, to resolve that. And appraisal will not kick in until such time as coverage is found. So in this case, and I think that's the crux of your appeal. In this case, you're taking the position. We all know that your client made a claim, well within the appropriate period of time, way back when, for Hurricane Irma. And as a result of that, the insurance company did, in fact, investigate, went ahead and made some payments and so forth. And then fast forward, which is beyond the 3 years, and this is what I want you to address. There's a statute, and I know you take issue whether or not this is a supplemental claim or an initial continuation of the initial claim. Given the fact that we do have a statute, which then was incorporated in the policy of insurance, help us out and explain why doesn't that provision apply in this case, where it's undisputed that your client for the second, let's call it the second claim, was well beyond the 3 years.
Yes, well, Your Honor, I guess there are two aspects to this. The first is that, from a more broad legal perspective, this statute is intended to address what had arisen previously in other cases. In the 3rd District, there are Fernandez and Hernandez cases where you have no ability to inspect after a certain period of time. And this statute and its inclusion in the policy effectively creates a sort of, I don't want to call it a statute of limitations, but it more or less operates as a statute of limitations where it says beyond 3 years, there's no real ability to, or the suggestion is there's no meaningful ability to investigate. So your claim, and we're using the word claim there very specifically because this is in the definition of supplemental claim, which is a different word than is used in much of the rest of the policy, which is just the scope of the loss. Beyond that point, do not request any further amounts from the insurer because you're getting too far distant in time from the original cause of loss, and it's no longer appropriate. I think to this case specifically, and this actually goes to a large portion of the argument, specifically in response to the more recent decision in Ironwood from this court. When a supplemental claim arises, I think is a factually specific analysis. So you have presumably the initial reporting of loss, which is what begins the whole and starts the whole machine. But then at some point, and I think here, this was a main source of dispute below, and I think should be visited here as well. When the supplemental claim arises, could be the source of much discussion and could arise in a good number of ways. I think the sort of presumption, maybe from a big picture standard, is that, there's some form filled out, it would be sent in, that would be very clean, that would be very, that would be very nice, neat, tidy. But realistically, in many of these cases, you have kind of the admin code saying, insurers put on notice of loss whenever there's something essentially, that reasonably apprises them of additional, losses, amounts, and so on and so forth. Here, this October 2020 date, which is the date that the trial court ultimately found this supplemental claim arose. And, part of our argument is that the trial court did not really have competent, substantial evidence to make that finding. I mean, I guess we have to focus more so on that, in the sense that there's also, there was one witness in this case below, that was Royalwood's witness. This witness had essentially testified that in 2018, the insurer had come out and had inspected the windows. So presumably been informed of damages to the windows and doors, had come out and inspected these windows in 2018. And this October 2020 date is conceivably the date and estimate for those.
Mr. Coggin.
Yes.
Okay, I'm going to read from page 246 and 247 of the record. Ms. Fairchild, is it true that the plaintiff in this matter, Royal Woods Condominium, submitted its estimate for the windows and door claim for the first time in October 2020? Answer, I believe there was other estimates submitted prior to that. Mr. Yearwood is our public adjuster and is taking care of all that information for Royal Woods. And then on down, the questions asked again. Finally, the court said, if you don't know, ma'am, just tell us you don't know. And then after that, the question, ma'am, that's not my question. It's prior to October 2020, did the insured submit a claim for the entirety of its windows and door system at the subject property? Answer, I'm not sure if he submitted the entire insurety of the claim for the windows and doors. So the witness you're relying on, well, then it goes on to say, next question, did the public adjuster or the plaintiff in this matter submit a 6.7 million estimate for the window and door system? Answer, I'm not sure of the dates when he submitted everything. So how is the trial court erroneous in their decision when the only witness couldn't tell them with certainty what the dates were?
Well, Your Honor, I believe the focus there is whether the entirety of this claim had been submitted. I'm not sure still, depending on how entirety is defined, whether the entirety of the claim has been submitted, because—
Well, just focus on the doors. When were the doors first brought up? I mean, there's talk about the windows, but I see nothing in the record before us that shows that anything with the doors existed prior to October 2020.
Well, and that's, I think, a fair point here. I mean, in the sense that, previously at page 245, Ms. Fairchild attests, whether that she's aware of investigations the insurer undertook at the property, and answered, in 2018, there was a request to look at the windows and addresses the windows specifically. I think in terms of the way the record reads, it's not very clear that it's windows and doors versus windows versus doors. So I think part of the issue here when, defining supplemental claim is how precisely, expansive this supplemental claim, I guess, really is. So the problem with these insurance claims is that nothing is ever really determined until it's either done by an appraisal panel or by the court. And I think through this process of investigation and through this process of cooperation, which, by 2018 has been going on for give or take a year, by obviously 2020, when an estimate is submitted, there's a lot of back and forth between the insured and the insurer as they presumably continue to investigate this.
But what the trial court was looking at is what was the estimate? What was the prior information that they had? And we don't have anything before us that shows that they had all of that information at a date prior to that. That there was anything with regard to the doors, and all of a sudden a $2 million claim becomes a $6.7 million claim. So at a minimum, shouldn't they have what the case law requires is an opportunity for them to review that new claim? And then that's a separate question as to whether it was timely or not. But even if it were timely, shouldn't they have had a reasonable amount of time to investigate the doors and whatever additional window damages there were.
Yes, absolutely. I think the argument here is that the estimate does not provide that notice. The fact that they were provided notice that there's an issue with the windows, at least, I think the record bears that out, in 2018, to the degree that they come out, they inspect it. And then, 2 years later, choose that point in time to say, well, now I received a dollar amount. The dollar amount is not necessarily required. The admin code, for instance, as was argued below, requires essentially a notice that reasonably apprises the insurer that something's wrong. Because ultimately, under the policy and under the admin code, the insurer is the one who has a duty to investigate and adjust. I think in a lot of cases, what's really happening here is this is getting flip-flopped. And I think the context of all of this really bears consideration. Appraisal is essentially like an ADR mechanism. I mean, basically, it's a limited ADR. It doesn't determine the entire case and ultimate liability, but it determines the scope of the damages and it just determines the pricing. But it is an independent.
So if it's a scope issue, I mean, your client chose to put Ms. Fairchild, who's a member of the board, as their sole witness. When she even testifies, there's somebody, I forget his name now, who, Mr. Yearwood, I think, is the public adjuster who had all the knowledge that could have said all the things that you're saying. Hey, they went out with the doors were already included, the windows were already included, but none of that's in the record before us.
Yes, Your Honor. I mean, presumably Mr. Yearwood would have been able to testify with even more detail, but I think ultimately Mr. Fairchild attests to the fact that the insurer goes out and investigates the windows at a minimum in 2018, which, I mean, again, suggests that from 2018 to this October 2020 date, the insurer is aware of the fact that at least, again, the windows are at issue. And I think fundamentally that is kind of the point of apprising the other party of some claim. I don't know how an estimate alone. I mean, how was the estimate requested if they were not aware of these damages in the first place? I mean, what were they requesting an estimate of? The original claim? I mean, it's very difficult, I think, to say that, for 2 years where there was an inspection had, and again, there's no evidence kind of anything in the interim, but presumably during these 2 years, something's happening, to say that, well, geez, I never really understood what was going on until I received a dollar amount. It's in many ways kind of an arbitrary decision to choose that estimate and ignore. And I think even below, it was argued, well, don't worry about what my client did. Just focus on the fact that I received an estimate. An estimate is not a required document. If you look through the policy, there is a sworn proof of loss required. There is an EOO required. You have to provide documentation, very much like, I would say, discovery. You don't have to create documentation. So in the spirit of cooperation, the public adjuster, as is attested here, provides this.
Does the sworn proof of loss include anything about the doors?
I'm not sure that is in the record, Your Honor. And honestly, I don't recall whether there was sworn proof of loss ultimately requested in this case.
There was a sworn, I mean, there was testimony about a sworn proof of loss that's not in the record.
Yeah.
But, I mean, the burden would be on your client, correct, to have brought that forward and to show that all of that was properly being considered during this whole period of time?
Well, Ms. Fairchild ultimately attested that the association, and granted it was a sort of blanket attestation, all of the post-loss conditions that were requested of the association were completed. And again, I would kind of contrast that to the lower court's finding where it says, I find you did not comply with post-loss conditions. There was no competing witness testimony. I mean, presumably, this could have been fleshed out to a greater degree, but ultimately.
But she didn't ultimately know what was included in the claims or the dates of any of them. And on cross-examination, that came out that she really wasn't aware of any of that, correct?
I don't think, I mean, and this is my interpretation of that she's suggesting that she does not know what is included in the claim generally. I think after being asked several times whether it really, truly, absolutely was the entirety of the claim, with her not understanding what the full extent was, I don't think that's necessarily the same as her saying, she doesn't understand even in broad strokes what was brought to the attention of the insurer, which
Why should we overturn the trial court rather than defer to her judgment when she had all of this and she viewed the witness? She had it all in front of her.
well, I mean, I think there's uncontroverted testimony that says, for instance, we complied with all post-loss obligations requested of us. And I think that's an important point, requested, because these post-loss obligations don't necessarily just arise and must be provided, without any context. And the trial court makes the direct opposite finding with no further testimony to that point from the other side or otherwise. So I think beyond that as well, this is just a look at an estimate being provided, and that's not ultimately what triggers the claim. I think there's testimony of inspection in 2018, which suggests that this was ultimately known 2 years earlier.
Counsel, you are at 15, sir.
And with
your
that,
choice.
I will.
Okay. We'll turn to the appellee's presentation at this time. Is it pronounced Mr. Betar?
Vitar, Your Honor.
Betar with a long E? Okay,
Yes, sir.
thank you.
Thank you, and may it please the court, Patrick Vitar on behalf of American Coastal. We're asking this court to affirm the lower court's non-final order denying the motion to compel appraisal here. And the motion was denied on two bases. Judge Kazam and Judge Startle each hit one of the reasons. First of all, it wasn't right. Royal Woods filed suit within a month of presenting their supplemental $6.7 million claim asking for additional payments. Prior to that, it was a $2 million claim. Because of that,
Counsel, I would like to explore the final judgment or the order that's on appeal with you, if I might, and it may lend itself to your presentation. If not, at least I'll get the benefit of your commentary before we segue back. As my understanding, paragraph 6 of the trial court's order is consistent with lines 15 through 28 of the transcript at 255 of the ruling, and that is that the trial court didn't rule on Florida Statute 627, 701-32. Is that correct?
that is correct, Your Honor.
Okay, so if I look at the trial court's order, the trial court says basically plaintiff's demand for appraisal is not ripe. Appraisal is not barred because defendant did not have enough time to investigate it. Is that the right way to read this order?
That is how I read it, Your Honor.
So I noticed in your presentation, your memo before the trial court, you cited the Third District Court of Appeals opinion. Is it pronounced Romay?
Romay, yes, Your Honor.
Okay. I noticed in that case that the remand in that order was we basically reversed the orders and remand with directions that the trial court require compliance with the preconditions to appraisal. Is that what the trial court should have enunciated here too? That it's basically barred right now because you haven't had a chance to comply with the terms of the contract, and the statute, or is that implicit within? Because the word barred is apparently the one that we're arguing about, that language.
It is, and I think that the step that you're going to go back for compliance really depends on paragraph 6. The coverage issue was never determined.
I understand that, so it's not preserved for us to get to yet. The statute about 3 years. So my question is how I interpret the remaining 5 and how I analyze that. And I saw that citation, and I noticed that Judge Schwartz had an interesting concurrence there. But anyway, the remand struck me as being interesting that when the trial judge means barred in this situation, it means presently barred until you comply with the terms of your contract. And I'll address the other issue found in chapter 627 at a later time, whether there's a statute of limitations, quote unquote, problem. Am I reading this right, wrong, reading too much into it? Because I read your case and I thought it was very persuasive.
And I think you're right, and you'd be right on if this claim was presented before the 3-year period. I think appraisal is barred at this time. I think they need to figure out the coverage issue first. If there is coverage, then they can maybe re-raise their argument for appraisal on this. And this really goes back to, I guess, the dual track method that this court adopted in Leeward Bay.
That's Judge LaRose's opinion?
Yes, Your Honor.
Okay.
And
I remember judges sometimes better than I remember case names.
but I believe Judge Kazan was also on that panel for that opinion, as I was counsel on that as well, so I'm also pretty familiar with it. And I think that's essentially where they're at is you can come back, we'll do a summary judgment, I guess, on the 3-year limitation issue. If the judge finds that for some reason that doesn't apply here, they can come back and bring the request for appraisal. But at this point, and they can maybe abate to allow American Coastal to go and investigate the claim. The issue that we face, and I think as we transition into the 3-year limitation, the reason for that and the purpose of that is, especially with hurricanes, when a lot of the damage is exterior, windows, doors, roofs, as you get farther away from the date of the event, it becomes a lot more difficult to determine if the conditions present in 2020, 2021, 2022 actually occurred from a hurricane in 2017, or if this is just a natural part of time, natural deterioration, age, wear, and tear. So we're hitting a lot of.
And with that, Mr. Bittar, let me ask you this, because you've mentioned this in your brief, and I think Mr. Coggin mentioned as well. How'd you respond? Because you basically acknowledged that although, and this is your line, although Royal Woods did present some nominal window damage as part of that 2.5 million, it advised that it would present a supplemental claim for additional damage. How do you respond to the fact that, well, this is just simply a continuation, that it was expected to present more additional damage? So in essence, once a claim is made, it's a continuation of, rather than, oh, one is concluded and there's a brand new one coming up. Help me out with that.
Absolutely. And I think we need to take a step back because the appellant in its brief and today in the argument seems to infer as though there's no definition of a supplemental claim anywhere in the universe, when in fact there's one right in Florida statute 627-70132, and also in the policy, you'll find it in the appendix at page 133. And what the definition of a supplemental claim is, says, and I'm reading from the policy here, a supplemental claim or reopen claim means any additional claim for recovery from us for losses from the same hurricane or windstorm for which we previously adjusted. That's exactly what we have here. That was exactly what was in Ironwood, where it fell squarely within the definition of a supplemental claim. American Coastal went out there. It was primarily a roof claim. They presented a $2 million proof of loss as their claim. American Coastal adjusted it and paid what they thought was owed. American Coastal was then told they may be presenting a window claim, a window and door claim. Actually, I think it was just a window claim. Now, there's over 100 buildings here. So American Coastal said, okay, tell us which buildings, tell us what, if you're making this claim or not. They then came back in 2020 and asked for additional benefits, additional recovery from the same hurricane. That falls straight on with the definition in the policy, as well as the definition in the statute, which says a supplemental claim means a claim for additional loss or damage from the same peril, which the insurer has previously adjusted. So I think it's a little bit of confusing to say that there is no such thing as a supplemental claim. We don't know what a supplemental claim is. We throw a dart at a board and that's where the supplemental claim occurs. It's once we come out, done our adjustment, made our payment, if you come back and ask for any more money, that is a supplemental claim. And that goes all the way back to Romay. Romay, they weren't claiming new items when they came back 5 years later for an appraisal. They were just saying, you didn't give us enough money for what we claimed originally. That was a supplemental claim. And that's where Romay comes through. And I think Judge Casanueva, that's where you were going down with your path of questions before. I think really where we are is we look at the plain language of the policy, we look at the plain language of the statute. And I believe, Judge Casanueva, it was you and when we met in April on San Marco, who said, aren't we really bound by Leeward, even though it's up for review in the Supreme Court? Isn't this panel bound by the other panel's decision? And ultimately the answer was yes. I think this court is bound by the Ironwood decision. And I do believe there's also, I found this yesterday as I was preparing, another case before you on a similar issue. I'll do a notice of similar issue, but St. Andrews Verandas versus United Property, which I think Judge Kazan, you were on the oral argument for that one as well. This is the same issue we're seeing over and over again. There's a claim made at one point, then some years later, months later, another claim is made and suit is filed before the insurance company has any opportunity to go out and look at the newly claimed damages, adjust, investigate. And really, that's what Leeward Bay was saying with regard to the ripeness issue. Leeward Bay said a claim isn't ripe until coverage is acknowledged and there's been a meaningful exchange of information. Romay, there has to be a meaningful exchange of information. The phrase that triggers appraisal, if you and we disagree about the amount of loss, as Romay says, that contemplates that the parties have met and discussed the differences. There was no opportunity to discuss this new $6.7 million request for payment. So I really think that's what we're looking at with this claim, is that the plain language of the policy, the plain language of the statute, and this court's decision in Ironwood compels an affirmance of the trial court's order below. And if there are no further questions, I will rest on my briefs.
Thank you, counsel.
Thank you.
Mr. Goggin, you may proceed.
Yes, so in brief response, I believe one of the main issues that has come up is, and is worth considering at this point, is this issue of claim versus loss. There is, of course, a definition of supplemental claim. It is within that statute, and as opposing counsel has suggested, within the policy as well. It pertains specifically to that 3-year limitation, which functions as a statute of limitations. The appraisal provision refers to a loss. There are post-loss obligations. It says that in the event we disagree as to the amount of loss, that the loss ultimately ends up being determined by the appraisal panel, and so on and so forth. Part of the reason that this is the scope of inquiry, I guess, or the correct scope of inquiry, the loss as a whole, rather than this claim issue, is because I think exactly the issue here. So ultimately, how do we determine what exactly a claim is and when it's provided? Here,
Let me ask you this. Using Judge LaRose's opinion on behalf of the court in Leeward, it suggests that the trial court has discretion to move down certain tracks. It would seem that before we move down in the tracks that are set forth in the trial court's order, paragraphs 2, 3, and 4, and perhaps 5, the paragraph 6 needs to be addressed to determine whether or not, whether by policy or by legislative enactment, this case as a supplemental case is barred. If it's barred, then there's no reason for any further judicial expenditure of time, the party's expenditure of money as well. And it would seem that that's a flexibility that Leeward provides. Am I correct, or am I missing something? Please, if you could speak to that. I'll try not to take up all your time.
yes, well, I think ultimately that, whether or not a supplemental claim is barred is something that the trial court could inquire into. But I think the main issue here is that we just simply don't believe that that constitutes a supplemental claim, where you'd have, again, this evidence that the insurer comes out and again inspects the windows in 2018. I mean, we have essentially by 2020, 3 full years of involvement with this.
Isn't that what the purpose would be of whether the legal issues are ripe for adjudication for summary judgment under the new rule? Because if the facts are clear and the law is clear of the statute and or the policy, then it's not a question of your interpretation of the facts or Mr. Beitar's interpretation of the facts. It's what do the facts speak to? And then, you can go on the process. If it is not a supplemental claim, then, you can remove under that opinion of Romay towards the discovery process, because now there's enough time gone by for the investigation and meeting of minds and all that to exchange.
Well, Your Honor, I mean, even the application of that statute, it bars what? The supplemental claim? What happens to the original claim, so to speak? This is why
Well, in fairness, I no longer sit as a judge in the 20th Judicial Circuit. I don't know, because I don't have to answer that as a trial judge. I wait to see what the learned ones do down there that help me along to understand this.
Well, and I think that
what I'm saying, I guess, is your questions may be very valid, but to whom do you raise them?
Well, I think that's the direct issue here, because this exposes the flaw with analyzing this as a claim and a claim and a claim and a claim versus a loss. There's a reason appraisal pertains to a loss, and it resolves issues such as this. If the supplemental claim is barred because it's filed after 3 years, you still have, admittedly here, you have payment for the original quote unquote claim. You have admission.
Is it your position that there was nothing at all added when you filed the additional claim in 2020? So This is strictly the same issue that had been on the table the whole time.
No, Your Honor, not the whole time, but since 2018. 2020 put a number to the issue that was raised in 2018, namely the windows. But moreover, even if, again, we assume for the sake of argument that the supplemental claim is filed in 2020, we still have roofs, which, I mean, they're not even the subject of argument here.
But then wouldn't the burden, if you're saying that in 2018 it changed and nothing had happened, wouldn't it have been your burden to bring up to the trial court, hey, at least we're entitled to it on some of this and not other issues?
At least that, Your Honor, and I think the real argument is that it's the same loss, and the loss needs to be appraised, where these independent appraisers can determine whether or not they have sufficient information to proceed to determine the amount or not. If they say, no, we do not have sufficient information to proceed, presumably they attribute zero. It really is an ADR independent look at this claim and the scope. It's meant to speed things along. We don't want the insurer to be prejudiced to not have the opportunity to investigate. But I think this is not about ultimate determination of liability. It's about whether or not this should be handed over to this panel to expedite the resolution of certain aspects of this case, which is why it is the loss as a whole, not this claim versus claim versus claim versus claim. We just need enough investigation sufficient to allow them to meaningfully participate in appraisal. And here, where we have them on notice and an investigation in 2018 of windows, I would suggest that meets the definition of, at least sufficiently prepared to proceed to appraisal. The number itself is irrelevant because the appraisal panel is going to determine its own number, regardless of what we say or what the insurer says. I think that's the context in which we consider this.
Thank you, counsel. I've let you exceed your time limit, but I want to get the answer in fully before we came to a close. I thank you both for your presentation this morning. We, on behalf of the panel, wish you good health and hope you keep it too as well. Hopefully we'll get to see you all live and in person, as they say, in the future. Thank you very much.
Thank you.
We will bring in the next case, and I will wait from